Welcome to my overview of the approval pathways under the New South Wales Environmental Planning and Assessment Act. Environmental planning instruments consisting of local environmental plans and state environmental planning policies regulate the permissibility of development and the approval pathway in which they will fall under. LEPs and SEPs also contain categories of development known as exempt or complying development. If your development meets the criteria for exempt or complying development, then you do not have to go through an approval pathway, nor will be subjected to the mandatory environmental impact assessment. So what are the approval pathways? There's Part 4, Part 5 and Part 5.1. An interesting note to make is that environmental planning instruments do not specifically say that your development would be Part 4 or Part 5. Rather, it distinguishes the different types of development through specific type of terminology. For example, you'll see terms such as state significant development, development permissible with consent, development permissible without consent, and state significant infrastructure. So let's take a look at Part 4. Under Part 4 there are two streams of development, either state significant development or local development. Both streams are subjected to Section 79C of the Act, which is a merit-based approval. What that means is a decision maker will weigh up the social, economic and environmental impacts when determining whether to grant an approval or not. Under the local development stream, a proponent is required to prepare a statement of environmental effects, or in the case of designated development, an environmental impact statement. Sitting under the local development stream is also a category of development known as integrated development. If your development requires subsequent environmental approval, for example an Aboriginal Heritage Impact Permit under the National Parks and Wildlife Act or an Environment Protection Licence under the Protection of the Environment Operations Act, then you will trigger the integrated development process. That prior to the consent authority granting you your development approval, they first must obtain the general terms of agreement from that secondary regulator. The consent authority for local development will either be the local council or joint regional planning panel. Who actually determines your development will depend upon the value and who the proponent is. Now the second stream under Part 4 is known as Division 4.1 State Significant Development. A proponent is required to prepare an environmental impact statement, and the Planning Assessment Commission, under delegated authority from the Planning Minister, is the consent authority. Now, state significant development takes integrated development under the local development stream one step further. It actually excludes some legislation from applying. For example, under state significant development, you do not have to obtain an Aboriginal Heritage Impact Permit. Another interesting part is that whereby approval where it's not excluded, it has to be issued consistently. So for example, if your development under state significant development required an environment protection licence, then the New South Wales EPA must issue that licence consistent with your development approval under the Planning Act. Also sitting under state significant development is a gateway process for special types of development. For example, if your development is mining or coal seam gas on strategic agricultural land, you must obtain a gateway certificate prior to being able to lodge a DA. The whole purpose of this is that it's a first overview or a vetting process to make sure that your development is compatible with those, agricultural land uses. Now, state significant development was inserted into Part 4 upon the repeal of the Part 3A process. Part 3A existed between 2005 and 2011 and related to major development. So upon its repeal, a similar type of major project or a state significant development process was added to the Part 4. What that means is that that major projects is now bound by the rest of the sections under Part 4. So for example, if you've got a state significant development that you wish to modify, then that means it must meet the substantially same test and be of minimal environmental impact in accordance with Section 96 of the Act. Under the former Part 3A process, you did not have to meet that test. In addition to environmental planning instruments guiding developments under the state significant development process, the Planning Assessment Commission can also advise the Minister about a particular type of development that should be assessed under the state significant development. This is a bit of a safety net or a catch-all provision in the event that a new random type of major development is lodged that hasn't been considered before under a planning instrument. Let's take a look at Part 5. Part 5 is development permissible without consent. So Part 4 is development permissible with consent and or state significant development. Also, Part 5 differs significantly to Part 4. Part 4, as I explained a moment ago, is a merit-based decision, whereby a decision maker will weigh up the environmental, social and economic impacts when making a decision about an activity. Under Part 5, that does not apply. Part 5 is rather a test of significance. That means that you weigh up the environmental factors to determine if you're going to have a significant impact or not. Depending on what the answer is to that question will depend upon what approval pathway comes next. So, how do you assess that? Under Part 5, there's an assessment process spelled out in accordance with Section 111 of the Act and Clause 228 of the Regulations. Clause 228 specifies the environmental factors that must be considered. Hence, the document that you prepared is known as a review of environmental factors. Unlike a statement of environmental effects or an environmental impact statement, which is provided for under the Act or Regulations, you will not see the term review of environmental factors under the Act. Rather, it is derived from the Clause 228 factors, hence review of environmental factors. So, a determining authority will review an REF and determine if a significant impact is likely or not. If a significant impact is not likely, then the works can be approved and undertaken without any further consideration. If, however, a significant impact is likely and a determining authority is the proponent and is not a council, that means that activity must now be assessed under the Part 5.1 State Significant Infrastructure pathway, which I'll touch on in a moment. If, however, determining authority determines a significant impact will result and the proponent is not the determining authority or is a council, then they must prepare and consider an environmental impact statement under the Part 5 stream. Now, Part 5 is, I guess, normally related to infrastructure type development such as power lines, water pipelines, also can be schools, correctional centres, rail, etc. So let's take a look at Part 5.1. Part 5.1 is known as State Significant Infrastructure. A proponent is required to prepare an environmental impact statement, and the Planning Assessment Commission, under delegated authority from the Planning Minister, is the consent authority. Similar to State Significant Development, it excludes some legislation from applying. Again, similar to State Significant Development, where other approvals are not excluded, they must be applied consistently. Now, Part 5.1 probably most closely resembles the form of Part 3A. Of particular note is that modifications do not need to meet the substantially same or minimal environmental impact test. So there's a lot more flexibility for developments assessed under the Part 5.1 process. Again, similar to State Significant Development, the Planning Assessment Commission and/or Infrastructure New South Wales may make a recommendation to the Minister for particular types of development to fall under the State Significant Infrastructure process. Again, it's a catch-all provision similar to the one that we saw in the State Significant Development stream. So there you have it. There's the overview of the approval pathways under the New South Wales Environmental Planning Assessment Act. The rest of the presentation will just be based upon summarising those pathways that we just reviewed. So there's Part 4 with the local development stream, integrated development, and also the State Significant Development process. Not to forget about the Gateway Certificate for particular types of development. There's Part 5, which is a test of significance, which differs to the Part 4 merit-based approval decision. And lastly, we have Part 5.1, which is for the State Significant Infrastructure. So there you have it. There's the summary of the New South Wales Environmental Planning and Assessment Act.